Okay, good afternoon. Today I just want to talk a little bit about, first of all, about the previous video and a couple of other topics, particularly the Supreme Court case on free speech. I want to add a little more detail to that. Go back to just mention the panel 2 that I showed you on the philosophical beliefs. First of all, I wanted to add that my father had a very strong belief in learning to work, which I found an authoritarian idea, very objectionable, and formation of proper habits, and that you justify your what you have by what you could have done for yourself, by what you could have done with your own labor, which in a way is both a conservative and possibly a Marxist, if you looked at it that way, idea. So I just wanted to mention that, first of all, to open. And then I'll just show, just for a topical picture, there's me in Williamsburg back in 7th grade. We'll talk about that in another video pretty soon, but that's actually in Jamestown, actually. And then I wanted to go on and talk. I'll mention, first of all, today Smirkanic talked about the case of Missouri versus Biden and about the supposed collusion with tech companies to suppress information about COVID and vaccinations. And I was sort of double-edged about this. I had the vaccine 5 different times, and there's my card. 5 different times because I'm elderly. But I did appreciate the concerns of those, that some possible medications might have been not being tested enough. I did wonder about the ivermectin when I was hearing about it, and I did wonder whether young adults, especially young men who are otherwise healthy, really should take our mRNA vaccines. But I have to say that the gay community was very good about requiring vaccines. The bars, most of whose customers are young men, they were very strict on that. And the gay community, particularly the male community that's familiar outside of today's stuff, did very well with the pandemic, and possibly because of living in smaller households could be one reason. But another reason might be that some were taking PrEP and some were taking, even with HIV positive, were taking protease inhibitors. And those might have had I'm wondering if they had a suppressive effect on COVID. There were some studies in Spain about it that were a little bit inconclusive. But I just thought I would mention, I don't have a lot of detail on this Missouri versus Biden case. But yeah, I'm concerned that we weren't being told everything, even though I came out pretty well, and it made sense for me to get the vaccine quickly. In fact, my sense of smell came roaring back after the second shot. I remember that, but in March of 2021. But I do wonder about that. But the main thing I want to get on now to is well, first of all, just mention the Masterpiece Cake Shop versus Colorado a few years back, in 2018, I think it was. That was actually decided on a technicality because apparently the defendant didn't have enough respect for religion and really wasn't dependent on the free speech issue. So that's that. But to talk about the very important case of 303 Creative LLC versus Elenis et al. In Colorado. And let me just read a few passages to you from the opinion. And the first passage that's important is on page 9, and Judge Gorsuch is talking about talking, and I know this case was somewhat contrived. I won't get into that. But Judge Gorsuch is talking about the hypothetical scenarios that come out of the fact that this is a creative expression. Now, let me just say also, many people have little LLCs where they take on clients and do creative work for clients. And that might include things like copy editing somebody else's book or something. Or it might include, co-writing or something. And most of the time, they don't discriminate against people, but they will refuse to not deal with certain content that they don't want to deal with, and particularly if it has to do with sensitive issues. Some people want to work only on material that pertains to their religion, for example, Christian publishing or something like that. So some people do want to limit the subject matter they're willing to express, and that's very common with self-employed people. And this Colorado thing might have provided a little bit of a threat to that. So let's just read what he says here. 100 years ago, toward the end, in page 9, Mrs. Smith might have furnished her services using pen and paper instead of a website today, that is. Those services were no less protected speech today because they are conveyed with a voice that resonates farther than would from any soapbox, even publishing as in the 19th century. All manner of speech, from pictures, films, paintings, drawings, and engravings to oral utterance and the printed word, qualify for the First Amendment's protections. No less can hold true when it comes to speech like Mrs. Smith's conveyed over the internet. We further agree down here that the 10th Circuit, that the wedding websites Mrs. Smith seeks to create involve her speech. Again, the parties' stipulations lead the way to that conclusion. As the parties have described it, Ms. Smith intends to vet each prospective project to determine whether it is one she is willing to endorse. She will consult the clients to discuss their unique stories as their source material. And she will produce a final story for each couple using her own words and her own original artwork. Of course, Ms. Speech may combine with the couples in the final product, but for the purposes of the First Amendment, that changes nothing. An individual does not forfeit constitutional protection by simply combining multifarious voices into a single communication. As surely as Ms. Smith seeks to engage in protected First Amendment speech, Colorado seeks to compel speech Ms. Smith does not wish to provide. As the 10th Circuit observed, Ms. Smith offers wedding websites celebrating marriages she endorses, and the state intends to force her to create custom websites celebrating other marriages she does not. Colorado seeks to compel the speech in order to excise certain ideas or viewpoints from the public dialogue. Indeed, the 10th Circuit recognized the coercive elimination of dissenting ideas about marriage constitutes Colorado's very purpose in seeking to apply its law. We part ways with the 10th Circuit only when it comes to the legal conclusions that follow. While the court thought Colorado could compel speech from Ms. Smith consistent with the Constitution, our First Amendment precedents laid above teach otherwise. In Hurley, the court found that Massachusetts impermissibly compelled speech in violation of the First Amendment when it sought to force parade organizers to accept participants who would affect their message. And then he talks about the Boy Scout Dale versus Boy Scouts in 2000. As in Barnett, the court found impermissible coercion when West Virginia required school children to recite a pledge that can contravene their convictions on threat of punishment of expulsion. Here, Colorado seeks to put Ms. Smith into a similar choice. If she wishes to speak, she must either speak as the state demands or face sanctions for expressing her own beliefs, sanctions that may include compulsory participation in remedial training, filing periodic compliance reports or officials deemed necessary, and paying monetary fines. Consider what a contrary approach would mean. Under Colorado's logic, the government may compel anyone who speaks for pay, and we'll get back to that in a minute, on any given topic to accept all commissions on the same topic, no matter the underlying message. This seems like the most important sentence here, and it's at the end of page 11. You can note that page at the end of page 11. If the topic somehow implicates a customer's statutorily protected trait, Taken seriously, that principle would allow the government to force all manner of artists, speech writers, and others whose services involve speech to speak when they do not believe on pain of penalty, that they do not believe on pain of penalty. That the government could require an unwilling Muslim movie director to make a film with a Zionist message, or an atheistic muralist to accept a commission celebrating an evangelical zeal, so long as they make films on murals for other members of the public with different messages. Equally, the government could force a male web designer married to another man to design websites for an organization that advocates against same-sex marriage. Countless other creative professionals, too, could be forced to choose between remaining silent, producing speech that violates their beliefs, or speaking their minds and incurring sanctions for doing so. As our precedents recognize, the First Amendment tolerates none of that. Now, I'll just add here the observation that back in 2018, this is on my own personal site, I created a video, and I'll give the link at the end, called A Very Dangerous Thought Experience. It's back in April of 2018. I've linked to it before, so I'm not going to play it here again. But what I supposed in that was the possibility that over time, people like me might not be allowed to speak indefinitely and gratuitously, just expressing their opinions about various matters, of public policy matters, without establishing how that was paid for. Some of that concern goes back to the McCain-Feingold campaign finance reform in 2002, and it kind of blew up in 2006, or 2004 and 2005 rather, and there was a lot of flack about it in the Washington Times, and it actually had an effect and created an incident when I was substitute teaching. That led to the concern that over time, and then the Federal Election Commission sort of dropped its concern about it, but that was where some of this came from. But one of the concerns I've had is that service providers might not allow someone like me forever just to simply broadcast my views for free without showing some way of how it can account for how it was paid for, because that would, and then simply not participate in any other way in the system, because if everybody did that, that really would hollow out the system, and that may be one of the reasons why we're seeing such a polarization today. The only people who participate heavily in politics are on the extremes, and we've been seeing that since about 2016. And that may be one of the problems. So I've been very concerned that, and also people have to have property insurance, home insurance, and so forth, that could create an issue for getting particularly liability and property insurance for your own home if you are self-employed. So Judge Gorsuch is right in making a point about if you work for pay. The practical reality is that at some point most people need to get paid somehow, even if they have money, need to show that they can get paid for the work they're doing, at least partially. And it's sort of a skin in the game problem that I talked about, back in 2018, that I think we could see more of, even though the implications of insisting on something like that, if it ever happened, would be very hard to predict, and it would be very hard to enforce, because if everybody had to play ball and try real hard to sell things to people all the time in order to be online to prove that they were commercially viable. That was talking about when in 2019, at the end of 2019, when YouTube talked about the concept of commercial viability. Remember that in its terms of service when he was talking about COPPA. That's not COPA, that's COPPA. Remember that. if everybody had to do that and had to constantly sell to other people and pester them with phone calls and emails, and you can imagine the spam, the problems we would have. So maybe that's not a realistic expectation completely. But that was the concern I had, and I think Judge Gorsuch is to be, commended for pointing this out. And I do thank you for listening today.